Hi, everybody. This is a presentation about online services like LegalZoom or freewill.com, and if they are suitable for parents to use as DIY estate tools. So I think we called the name of this presentation Save Now and Pay Later. And the reason for that is that I have actually tried to probate a number of wills prepared by such companies like LegalZoom, and it's been a rough ride. So I'm Yana Feldman. I'm an estate planning and elder law attorney in Brooklyn, New York, and I want to talk to you today about what you can do as parents who want to protect your families, protect your children, plan for the future, and ideally not spend a ton of cash on this. I'm going to give you some tips for a few things that you can do on your own and some things that you really shouldn't. Okay, let's get started. In preparation for this presentation, I went to freewill.com and I created a last will and testament. I honestly answered all of the questions. I followed their prompts. I tried to pretend that I didn't know about these concepts and just answer the questions that they asked me and not second guess them. And then I reviewed the will the way I would if someone brought it to me and said, my family member, Yana, passed away and I need to probate this will. And I'm going to go through a list of issues that I spotted that might be a situation that your family has as well that would be untreated, would not be addressed in the will that you can get from freewill.com. So number one, what if your spouse or children became disabled? There's no provision for that. Which is concerning because sometimes someone is already disabled. Sometimes someone might become disabled after you've prepared your will. And in either of those cases, those assets should go to a trust for their benefit, where someone can use the money for them and let them have whatever government assistance that they are entitled to due to their disability or due to their lack of ability to control and manage those funds. Number two, according to this will, my children would inherit outright at age 18. So if something happened to me and my children were 19 or 20 years old, they would receive their inheritance outright without anyone to guide them or assist them in deciding how to manage the money. Number three, what if someone that you've named in your will, not your beneficiaries, not your heirs, but maybe your executor or your trustee or your guardian, what if they became disabled? Or what if they started doing a bad job? There's no provision to remove them or to appoint somebody else. What if one of your beneficiaries isn't disabled but has some other unfortunate circumstance? What if they have a gambling problem, a substance abuse problem? What if they're in a lot of debt? What if they've been sued and they have a judgment against them? In this will, there are no provisions to cover that. So they would still inherit whatever they're entitled to inherit and potentially could lose it, or not only lose it, but they could also harm themselves even further because now they have a lot of access to cash. A few other things. When I prepared this will, I wasn't asked about the total value of my estate. They did ask about what assets I had, but they didn't ask about the value of my life insurance policy. A lot of people don't know this, but when we count your estate to see if there are estate taxes due or not, we have to include the proceeds of a life insurance policy. So there's a lot of opportunities to save or completely eliminate estate tax for many families that would be taxed if they followed the instructions in this will preparation guideline. And then my favorite, or possibly the one that upsets me the most, because I've had to deal with this after someone passed away several times, there is a special affidavit that needs to be signed by witnesses. And if you look for those witnesses 30 years after a will is signed, guess what? They're pretty hard to find. So an experienced estate planning attorney is going to have the witnesses sign that affidavit at the same time they sign the will. And that way, if they move away, if they pass away, if you just can't find them, you're fine. That will be able to be probated with no problems. So if any of the things that I've brought up are a concern to you, you probably don't want to use one of these do-it-yourself will preparation programs. Oh, and I'm sorry, another one that I didn't mention. What if you have children who are not also the children of your spouse from a prior relationship? You know, do you want to provide for them, or do you trust that your spouse will provide for them? You know, maybe you do, maybe you do. But I always have to look out and make sure that as a parent, the children are protected, okay? So I've thrown around a lot of concepts, and maybe there's some words that you don't recognize, but if, you know, if you're interested in learning a little bit more about this, I'm now going to talk about 3 things. I'm going to talk about what a will is or isn't. I'm going to talk about why a will might not be the best document for you as you plan to protect your family. And I'm going to talk about some of the biggest estate planning mistakes I've seen people make over and over again. So number 1, what's a will? A will is a document that you prepare. In New York State, it has to be witnessed by 2 people. And ideally, they also sign that self-proving affidavit and have it notarized at the same time. In your will, you appoint an executor. That's the person that you've selected to carry out the terms of your will. You list who are your beneficiaries, who will inherit and receive your assets under this will. You can also create trusts where you're asking someone to hold assets for the benefit of someone else. We usually see that for children or young adults. Many of my clients leave assets in trust to their children until they're 35 or 45 years of age. And they appoint a trustee who can monitor the usage of those funds. You can appoint a guardian to take custody of your children until they're 18 years old. And you can even set out your wishes for burial or cremation, your final arrangements. Now, until you pass away, that will has no validity. It's not binding on anybody. It can be changed at any time. As a matter of fact, if you have a will and you just rip it up, you've canceled it. It's gone. Now, if someone passes away and the family says, well, we have this will, what do we do with it now? What does it control? How does it control? First thing I want to mention is a will does not control what we call non-probate assets. What does that mean? If you own a property jointly with someone and you pass away, they will inherit the entire property. If you have a beneficiary, like a life insurance policy usually has a beneficiary, a retirement plan usually has a beneficiary. Most bank accounts can have beneficiaries. Those assets will pass to those beneficiaries. So in your will, you can say, I leave everything to my spouse. But if your beneficiary is listed and it's your girlfriend, guess who's getting those accounts where the girlfriend's listed? It's not the wife. A lot of times people come in and they think that making a will that says, I leave everything to so-and-so is going to control all of their assets. But that's simply not the case. So we have to make sure that as estate planners, We're going to go through all of the assets that a client has. We also talk about assets that they don't have yet. We talk about their parents or grandparents. Are you anticipating an inheritance? Maybe someone is a young professional and doesn't have a lot of assets, but they have a grandmother who's very fond of them, and she owns a house that's worth quite a lot of money, and she's in her late 80s. You know, we wish her well, but at some point she will pass away, and maybe she has a will that leaves the house to her grandchild. So now that grandchild will actually be worth quite a lot of money. So the will is prepared, the will is signed, we've considered all of the options, we've considered the entire family, and the person has passed away. What happens next? A will has to be submitted to the surrogate's court, where the surrogate, that's the judge in the surrogate's court, has to admit the will to probate and issue a decree which authorizes the executor to carry out the terms of the will. How do you get there? Do you just drop it off at the courthouse? Not exactly. First, you have to pay a filing fee. That's usually around $1,250. Someone has to prepare a petition. It's not impossible to do on your own, but for most people, it's quite confusing and is going to require a lot of frustrating trips back and forth to the clerk's office. So factor in a few $1,000s to pay an attorney to probate that will. Now, assuming that everything goes smoothly, assuming that everyone cooperates, assuming the will was properly executed, properly prepared, etc. The petition, the supporting documents, the filing fee are all submitted to the court. The clerks review it, and then it goes to the judge. So we're done? Not exactly. If you have children, if there are any minors under the age of 18, the court will appoint a guardian ad litem to protect their interests, even if they have a surviving parent, even if they're not inheriting anything under the will. If someone passes away and they have children under the age of 18, the court will appoint this guardian ad litem. This is an attorney who is appointed to represent the interests of the minor child. Now, they're going to do their own investigation. They're going to possibly talk to the drafting attorney and the witnesses. They will talk to the surviving family. They will talk to the child. They will look at the totality of the circumstances. They're trying to make sure that this child's rights to inherit from their parent are not being stolen away from them, that this is really what the parent intended to do. Guess what? They're going to present a bill and a report to the court. They're also going to present a bill, and that bill will be payable from the estate. Also, it can cause a lot of delay, right? If there are family members living abroad, we still need to find them. When you probate a will, you have to find everyone that would have a right to inherit if there was no will. That's a lot. That potentially could be a lot of people. So it's a spouse, it's children. If there are no children, it's parents, siblings, cousins. Sometimes we have to hire genealogists. Spent tens of thousands of dollars on a single case on genealogists trying to track people down. We have families where, you know, siblings haven't talked in 50 years. They don't know where the other one lives. They're already deceased. They have children that haven't even heard of the decedent. We have to track them all down and document and prove it all to the court. Phew. I'm tired just talking about that. But that is the process of probate for a will. Every single I has to be dotted and T is crossed. And if any of the requirements in New York State aren't met because the will wasn't prepared by a New York attorney, that can cause further delay. It can also cause the will not being accepted to probate. What happens then? What happens if there is an error in the will document that is not curable? Then we look at New York State law. And New York State law is a formula. If you pass away with a spouse and children, Your spouse gets the first $50,000, and then everything else, 50% to the spouse, 50% to the children. If you don't have a spouse or children, it goes to your parents if they're not living, to your siblings, to their children, and so on and so forth. A lot of times this results in a situation which is not at all what the decedent wanted. So the importance of having a properly drafted will that will stand up scrutiny, that will be admitted to probate. How long does it take for a will to be admitted to probate? I have had cases where it takes as little as 3 weeks. This was, of course, pre-COVID. Unfortunately, I have not had any wills admitted to probate that were submitted after COVID started. The courts were not accepting any submissions for a period of time. Then they were accepting very limited submissions, and they're now accepting more submissions, but the backlog is huge, and it is just taking a very, very long time for wills to be processed by the court. And there are some families that are really suffering because of it. The monies are tied up. They cannot be released until the will is admitted to probate. There are some procedures to try and speed that up, but it is still not a speedy process, even at its best. So that leads me into the next point I wanted to make, which is going to be an entirely separate presentation, but I want to raise the question. Is a will actually the document that you want? If your goal is to make sure that your family doesn't go through a hassle, if you want to make sure that there are assets available right away if your family needs them, you should consider using a revocable trust. It's sometimes called a living trust, and transferring assets to a revocable trust or making the revocable trust the beneficiary of your accounts. If you, and again, speak to an estate planning attorney and properly plan your estate, it's very simple to make sure that your family does not have to go through the probate process. Now, these living trusts are also available online, but all of the issues that I have mentioned with the wills, all of the special conditions and situations that are not addressed by fill-in-the-blank documents would be the same problem in a trust as they are in a will. Now, the biggest estate planning mistake that I see, and I see it all the time, listing your minor child as a beneficiary on a life insurance policy or an account. Guess what? Children under the age of 18, they cannot inherit money outright. So there are a few exceptions for very small amounts, but typically what needs to happen is that someone has to go to court, even if they are a natural parent of this child. If you are married and you have a life insurance policy and you decide out of love and affection and desire to provide for your child that you're going to name your 5-year-old the beneficiary, guess what's going to happen? Your spouse, if you pass away, your spouse has to go to court. They have to ask the court to be appointed guardian of the property of your minor child, even though they're already the parent. The money will be put into an account that is monitored by the court and the guardian. There are very strict restrictions on that money. And when your child is 18, they get all of it with no control. That's very rarely the desired outcome of most people. Yet, over and over again, I see people who have listed their minor children as beneficiaries. There are better ways to do this. And again, this is one of the things that you would discuss with an estate planning attorney as you make your estate plan, versus if you make a will on the internet. This is usually not something that is addressed. The beneficiary designations of assets that are not controlled by your will. There's a few other points where I feel an experienced estate planning attorney can bring a lot of value to your situation besides that. In general, we've had hundreds, if not thousands, of consultations with clients. We have seen every different family that's out there, and then some. So we have seen the different types of problems that have come up. We anticipate issues that might arise, and we can bring up questions that you may not have even considered. When you work with an estate planning attorney, we're a little bit detective and a little bit therapist. We poke and pry. We ask you really sensitive questions because we want to know why you want to do something. A lot of times people come in with some initial instructions, and I have said to clients, word for word, I understand that you're telling me you want X, Y, and Z, but I'm not a waiter. I'm not an order taker. I'm an estate planner. I need for you to explain to me why you want X, Y, and Z. What is the goal that you want to achieve? What are the issues that you are concerned about that you think this will address? And many times the estate plan that I can propose to them and create for them is going to accomplish their goals and address their concerns much better than their original idea. So that, lawyers are sometimes called counselors at law. And as an estate planning attorney, I take that very seriously. I'm here to work with my clients to identify their concerns and to advise them their options and how they can address them and achieve their desired outcome. We're also going to make sure that we get the big picture. We're going to learn all of the little details. We're going to learn about potential inheritances. We're going to learn about your business. We're going to learn about the potential for litigation against you. We're going to, learn about where your family members are. This is another issue that really stood out to me as someone who is an immigrant, as someone who has friends and family that live all over the world. In New York, there are many people like that. And there are certain points that were not raised in the online interview. For example, if you appoint someone as your executor, who are you going to appoint? For many people, they want to appoint a close family member. Should I appoint my sister who lives in England? Not if she's not a US citizen. That could be a real problem. So again, this is another reason why, if your family has people living abroad, you might want to speak to an estate planning attorney. So if you do want to speak to an estate planning attorney and you want to avoid the potential pitfalls of do-it-yourself online legal document preparation, how do you find this attorney? How do you choose this attorney? Maybe you're not in New York, so you can't work with me, or you want to find your own attorney. That's great. Here are some tips for how you can choose an estate planning attorney. First things first, ask your friends or relatives, ask other professionals that you have relationships with. Do you have a good estate planning attorney? Now, if they give you a name, ask a few more questions. Have you worked with this person, or do you know them socially? Have you met this person in a networking group, or have you had mutual clients? And this is actually one of my favorite questions. Do you know a family where a family member used this attorney and then passed away? Because here's the thing about do-it-yourself estate planning versus do-it-yourself construction or, home improvement, sewing, whatever it is, even financial investments. You do it yourself, and if it doesn't work out, you can go find a professional and fix it. If you do your estate plan yourself, by the time your family learns that you didn't do it properly, it's too late to fix it because you're gone. We don't learn about the mistakes in your estate plan until after you've passed away, and then the plan is tested. When you work with an attorney, first of all, that attorney has professional liability insurance. And as an estate planning attorney, it's a bit expensive because it covers us. Our professional liability insurance covers us for a long period of time because they know that I could write 100 wills this year and nobody will know if those wills are good or not until years down the road when these clients pass away. So I think that's a great question to ask. Do you know someone who has used this attorney and has lost someone in their family and then gone through the post-death process with the documents and the plan that this attorney prepared? You can ask about education. You can ask about years of experience. You can ask about their process. You can ask about how they bill. Do they bill hourly? Do they bill flat fee? I will caution that it's very hard to quote a fee without having a consultation, because a lot of times people think that they have a very simple situation, and it isn't until we sit down together and we unpack what's going on that we learn, that the planning might be a little bit more complicated in order to get the desired outcome. So you can ask how they bill, but it is difficult to say exactly how much a legal fee might be. You can ask about the education that the attorney maintains. We are required to take continuing education courses every 2 years as we submit our attorney registration. But does this attorney go beyond that? Does this attorney, are they enough of an expert that they maybe teach classes to other attorneys or other professionals? And here's another great question to ask when you're looking for an attorney. What happens after I sign my documents? Is it bye-bye, see you soon? I think that a great attorney is going to stay in touch with you after you sign your documents, is going to reach out if there are major changes in the law, provide some updates. Sometimes there are subscription programs where you are entitled to a consultation with that attorney every year or two to discuss changes in your life and updates to your plan. But I think that's a great question to ask. And the last one I'll mention is how much of your practice is devoted to estate planning. There are some firms and attorneys that devote their practice to estate planning. There are some attorneys who cover, matrimonial, immigration, criminal, civil litigation, and trust and estate planning. So you're going to have to decide, is it important to you to have someone that really focuses on this? So another point I wanted to discuss with you is how to prepare to have a consultation with an estate planning attorney. You've thought about your family. You have heard a few things that I've mentioned that, yeah, that's something that I'm concerned about. And you've decided that you at least want to speak to an estate planning attorney before you DIY your estate plan. So the simple way to prepare is to make a list of your assets. What do you own? How do you own it? Do you own it by yourself, with someone else? Are there beneficiaries? It's important to know if a bank account is a retirement account or not. And then there are some other questions to think about. And these are questions that your estate planning attorney can discuss with you and flesh out. but some questions to start thinking about. If I passed away, who do I want to wrap up my affairs financially? If I pass away, who do I want to care for my children? What kind of life do I want for my children? Do I want them to be able to stay in the same home? Is the person I'm thinking about as a guardian willing to do that? Do I need them to stay in the same community, in the same country? Do I want them to go to another country? How do I financially want to prepare for the possibility that I might not be there for my children? Do I have enough life insurance? Are my assets going to be enough? Are my assets going to be readily available? And that goes back to the point I was making earlier about how a will might not be the best document for your family. You might want to consider a revocable trust, a living trust, some people call it. Another thing to consider is a trustee and a trust for your child. Are you comfortable having your 18-year-old have access to everything that you've accumulated during your lifetime? Do you want to name someone or a series of someones that are going to be able to control their access? Have you thought about what instructions you would want to give that person? What are the values that are important to you? For example, for me, something that I wrote in a document that I prepared as part of my estate plan, and I'm going to provide it as a free download to everyone that's watching this video. I prepared a document called an ethical will. And this is not a legal document, but it's a series of prompts that asks parents to write out what their beliefs and hopes and wishes for their children are. To be a little superficial, I have always talked with my little girls about going to Paris, and I included that I want my trustee to make sure that by their 16th birthday, my children get to go and spend some time in Paris. It's something that I, as their mother, want to do for them, even if I'm not here. You can also talk about religion. Some people feel very strongly about religious education and upbringing. Some people feel the opposite, that they want to make sure their children do not go to a parochial school. So these are things that you can start thinking about. What is important to you? And are the people that you have considered to appoint to these roles, are they going to be able to comply with or follow these desires of yours? So that's a little bit about the pitfalls of DIY estate planning and the benefits that an experienced estate planning attorney can bring to the process of estate planning. I mentioned that we have some free downloads that are available for anyone who's watching this presentation. The first one is that ethical will document that I mentioned. The second is a designation of standby guardian. In this document, you can appoint who you would like to take custody of your children if there was an emergency. It's a short-term document. It's not finalized, but in the case of emergency, especially now when we have all of the travel restrictions, you can appoint who is local, nearby, and make sure that your child can go home that night with someone that knows them and cares about them. Finally, we would be happy to provide what we call healthcare directives. Healthcare directives are a durable power, healthcare directives are the healthcare proxy, the living will, and the HIPAA form. And this is really the only part of the estate plan that I would feel comfortable telling my friends and family members to DIY. These are forms that are available on the internet for free. We can provide links to them. You can print them out, read the directions, and fill them in. And those are going to be a great basic document that you can have on hand in case you were to become incapacitated or disabled. So that is about it for our presentation today. I hope you learned a few things. If you have any questions, I'd love to hear from you. You can get in touch with us by emailing support@yanafeldmanlaw.com, going to our website, yanafeldmanlaw.com, or calling 718-713-8080, 718-713-8080. We would love to speak with you, so please feel free to reach out and schedule a consultation. We can talk about your questions and concerns and hopefully get you set up with an estate plan that's going to meet your family's needs